Good afternoon, everybody. Welcome to Pump Court Chambers seminar, Resolving Inheritance and Probate Claims in Lockdown. What does ADR happen? What does ADR offer, forgive me? And we're hoping to persuade you that the answer to that question is rather a lot. I'm here this afternoon with Tara Lyons, and despite the backdrops, we're not in parallel universes. It's just one of us has our camera mirrored and the other doesn't. Obviously, one of the major drivers towards ADR at the moment is the impact that COVID-19 has had on court hearings. There have been a few relatively modest amendments to the CPR to address it. There's CPR PD 51Y, deals with video and audio hearings, although really the impetus behind that is the involvement of the press and the availability of those hearings to the public. PD 51Z deals with stay of possession proceedings. Obviously, that's a very important issue dealing with tenants. And then PD 51ZA, extension of time limits and clarification of practice direction 51Y. And I think you know you're in a morass when you see a practice direction where they run out of letters. And 51ZA is clarifying 51Y. The real useful bit of 51ZA is it just tells you that the ability to extend time limits by agreement between parties is temporarily extended from 28 days to 56, and that will last in the first instance until I think it's the 20th of October. We've then had this document from the Courts and Tribunals Service. It's headed Civil Court Listing Priorities, although if you look right at the end in the small print, once you've flogged all the way through it, it very helpfully mentions in the concluding sentence that it only relates to county court work. So this perhaps might more helpfully be headed County Court Listing Priorities. And we see there they divide it between work that must be done and work that could be done. Work that must be done, as one might expect, freezing orders, committals, injunctions, matters which are of necessity urgent. And then towards the end of the list there, you see applications in cases listed for trial in the next 3 months, applications where there's a substantial hearing listed in the next month, multi-track hearings where the parties agree it is urgent but subject to triage and appeals. And then work that could be done include things like infant approvals, enforcement of contracts, set aside judgment in default. And it's, I understand from speaking to friends and colleagues around the country, wildly different picture depending on where one is as to how much of that work that must be done is actually getting done in a reasonable time, and how much, if any, of the work that could be done is being done. If we move on to see what the High Court has produced, the High Court has firstly a contingency plan, which is a fairly brief outline document, and that splits not work into work that must be done and work that could be done, but into urgent business and business as usual. Business as usual is a spectacular misnomer, I think, in many instances. But business that must be done is very narrowly defined indeed. It's business that would be sufficiently urgent to warrant an out-of-hours application in normal times. And we know that is a vanishingly small proportion of what we do. Urgent business is given priority. It is not appropriate to define urgent business any more closely. If the relevant duty judge does not consider the application to be urgent business, it will not be dealt with. So pretty clear there. A more substantial document came out on the 26th of March, Civil Justice in England and Wales, Protocols Regarding Remote Hearings. This is more comprehensive guidance. We could spend an hour just going through this, but I just want to flag up a few key points in it. Paragraph 7, the following legal issues are to be addressed before any remote hearing can begin. 1, whether the hearing is to be in public or in private, and if in private, on what grounds, just recognising that the court doesn't have a general discretion to deal with matters in private. there has to be a justification for it. And second, how is the hearing to be recorded, or can an order properly be made to dispense with recording? And I understand, again, speaking to colleagues, that that's been a particular concern and at times difficulty in some county court cases. In the present circumstances, the court and the parties and their representatives will need to be more proactive in relation to all forthcoming hearings. And I think that really is key. The parties are expected to liaise insofar as they can with the courts, which of course has its own difficulties because many courts up and down the country are entirely closed and only work on paper files which can't be accessed remotely. It's good practice for the listing office, judges, clerks and court officials to consider as far ahead as possible how future hearings should best be undertaken. That in practice is very often by telephone at the moment. There's a well-established difficulty with Skype for Business, which is the court's preferred video conferencing facility, which it turns out not to be compatible with the latest Mac operating system. And that's, again, been causing considerable difficulty up and down the country. It will normally be possible for all short, interlocutory or non-witness applications to be heard remotely. Some witness cases will also be suitable for remote hearings. And it's worth noting there that FDRs, early neutral evaluation, probably fits quite neatly into that definition of short interlocutory or non-witness application. Paragraph 23, an important change to the usual. The clerk, court official or judge must complete the order that is made at the end of the remote hearing, although the wording of the order should be discussed and agreed with the parties. I think in practice that will often mean that counsel will be invited to come up with a draft on behalf of the court. Moving on then. Forgive me, I'm just seeing if I can move that slide on. Yes.
I'm going to speak now about moving into ADR because whilst remote hearings are happening, and particularly as Mark's mentioned, FDRs and ENEs, it's important to remember that one's got to consider ADR not only prior to proceedings, but at all stages of litigation. And we feel that they're of particular prominence, given the inability of courts to continue to hear a number of hearings. That prominence is given not only in the CPR, but also, of course, Chancery Guide and the Jackson ADR Handbook. And just a reminder that paragraph 8 of the practice direction on pre-action conduct sets out very clearly that starting proceedings should usually be a step of last resort. Although ADR is not compulsory, the parties should consider whether some form of ADR procedure might enable them to settle matters without starting proceedings. The court may require evidence that the parties considered some form of ADR. Whilst not perhaps compulsory in a literal sense, it is clear, and we'll go on to have a look at this in more detail, that any party refusing or ignoring an offer to ADR is running a very, very great risk of a serious cost sanction at the end of the day. So what constitutes ADR? It is more than just mediation, and I think it's important to remember that. Discussion and negotiation, as set out at paragraph 8.2 of the practice direction, also constitutes ADR. Mediation, early neutral evaluation and arbitration, and we'll be having a look at the different forms of ADR in due course. Whilst there are different forms of ADR, I think it's important to say that particularly when looking at cost sanctions, it's our view that you would be wise to always consider mediation at the outset prior to proceedings, and then go on to consider other forms such as early neutral evaluation, FDR. But skipping mediation because you might undergo an early neutral evaluation later after proceedings have started, we would say is probably a risky approach. So an early neutral evaluation can also be intertwined quite easily with a financial or family dispute resolution hearing. Those who practice in family will be more familiar with the financial dispute resolution hearing because they are a mandatory hearing in financial remedies cases. And I personally have conducted both ENEs and FDRs remotely in this current time, and have found them to be very effective, and the courts have shown a willingness to continue to conduct these hearings remotely, and we'll have a look at the practicalities of that in due course. Mark said to me earlier today, well, yes, they're willing to conduct these hearings if they're already listed, but are they going to be willing to list these hearing given the urgency of what the other hearings they have in their lists are? Probably not, and he's right about that. But that doesn't exclude looking at holding ENEs and FDRs privately, and that is an option which is finding more favour, particularly as barristers or find themselves with emptier diaries, and there's a real competition at the moment between sets, and you will find some very competitive prices. So let's have a closer look at ENEs and FDRs, just for those that may not be as sure as what they are. An ENE, early neutral evaluation, is a hearing where a neutral lawyer or judge will provide the parties with an assessment of the case and a legal view of the merits. It's a without prejudice hearing, so that means anything said in the hearing will not be used at any trial. The evaluation or indication that is given is non-binding. So you are not, if you like, at any risk if you don't accept it. You're not forced to accept it, apart from potentially a cost risk if there are generous offers made that have been refused. We would say that ENEs and FDRs in particular are very well suited to multi-party family provision claims because it is an opportunity at relatively lower cost to a full-blown trial of bringing all of the parties together and a judge or evaluator being able to cut through all of the various issues that may be present in a case. And it can really bring a swift resolution. And as I say, cheaper than a full-blown trial. Yes, Mark?
So, sorry, if I can just chip in there. It's interesting, the early neutral evaluation has now come to be seen as primarily a judge-led process and is now provided for in the CPR and the Chancery Guide. But for many years, it was regarded by practitioners primarily as a private and independent process whereby parties would approach an independent lawyer or sometimes a surveyor in buildings cases for a joint early indication, often in a low value claim and often in writing. It didn't have the connotation of being a hearing or a meeting so much in those early days. Yeah. And I think particularly now, this is probably a good way of resolving low claims. If the parties can agree a set of instructions to an independent evaluator, you can do that with no concerns about social distancing, no concerns about technology. You're likely to get a quick turnaround, and it will often be a way of resolving a dispute that perhaps doesn't merit the investment of a full-blown mediation.
Yes, that's right. Thank you, Mark. There are two distinctions between FDRs and ENEs, which I just want to highlight. The first is probably a technical distinction, which doesn't really make much difference in practice, and that is that an ENE, strictly speaking, was supposed to be just the evaluation. The parties would approach the judge, either giving written submissions or oral submissions. The judge would give the evaluation, his or her evaluation of the case, and that would be it. An FDR was a much more facilitated negotiation after the evaluation, and that allowed the parties to give their submission, make their submissions to the judge. The judge would give his or her evaluation. The parties would go outside and negotiate, and if there was still a gap between them, the judge would carry on facilitating the negotiations. In practice, judges, particularly privately, are happy to go that extra mile, and it's not strictly the evaluation. The second distinction is perhaps a more important one, and that's this. FDRs can only take place in civil proceedings if all of the parties consent. The court will not order an FDR without the consent of the parties. And of course, private FDRs have to have the parties' consent. On the other hand, ENEs can be ordered as part of the court's case management powers. And CPR Rule 3.12M specifically provides that the court may take any other step or make any other order for the purpose of managing the case and furthering the overriding objective, including hearing an early neutral evaluation with the aim of helping the parties to settle the case. If there was any doubt about whether the court could order an ENE without the consent of the parties, then Lomax and Lomax quickly put that doubt to rest. It's a 2019 Court of Appeal case in which the court specifically said, yes, the court has power to order an ENE without the consent of the parties. So that's a useful case to rely on if you think your case is suitable for an ENE and you want to push it towards one. Let's just have a moment here to talk about how you might conduct an ENE or FDR remotely at the moment and what things are important to consider. I have had 4 ENEs and FDRs, and all but one of them has been a success. What I found is that to enable it to run smoothly, you've got to make sure that you are in close contact with the court as far as possible, because of course Mark's point that lots of them are closed and it's difficult to get in contact with them is true. But as far as possible, to consult the court in respect of how it's going to be conducted. Does the judge want to have a telephone hearing, or does he want to use Skype for Business or some other video conferencing facility? The important thing to remember is that the judge, well, certainly in my cases, the judge will always want to have the hearing recorded. It's going to be a rare case where it's not recorded. As Mark said earlier, permission will be needed in that respect. And so is the method you're proposing to use, if the court isn't going to be in charge of it, is the method you're proposing going to enable a recording? I had a case where one of the parties was in Norway, and the court's proposal of telephone conferencing would not allow a foreign telephone. And so we had to, my instruction solicitor had to arrange it, and we just used Powwow Now conferencing, which had a recording facility, and that worked fine. Just because the court hearing itself may be conducted by telephone, it doesn't mean that your conference with the client should be. I have accompanied the telephone hearings with a video conferencing, not only with my client, but also my opponent. And I found that particularly helpful because you can build a closer connection with your client. You can gauge your client's responses better to your advice, seeing their body language, seeing their response. and it enables them to feel more fully involved with negotiations. One big warning I would say is, even if you're particularly well versed with the technology, please don't assume your client or opponent will be. So always test your technology at least a day before with them. And I would say that another point is that everything is that much slower when you're dealing with it remotely. So I would advise you to have your conference with your client and counsel certainly the day before the hearing, so you're not doing a rushed job early in the morning of the hearing. And that's not least because in this time of remote hearings, I found judges are starting the hearings on the dot of the time that they've allotted to you. They are not giving you a few extra 15 minutes to come into court. And so you have to be ready to start promptly. And that's another reason for meeting the client the day before using the video facility. I also always meet with my opponent the day before so we can run through the conduct of things. I tend to make my offers by email whilst I'm dealing with it remotely, so that the client can be CC'd in and there's no issue with recording what's been said incorrectly, and it provides a very helpful record for the day and something for the client to be thinking about before you get back to him to take instructions. Appropriate screen breaks. I found that the remote hearings I've dealt with have started at 8:30 in the morning and finished at 8:30 at night on some occasions. And it goes without saying that you need to take appropriate breaks from screen because it can be particularly exhausting. And I think, Mark, you were commenting that a number of the judges you've spoken to have said they found the remote telephone hearings particularly exhausting as well. So you need to factor that in.
If I could just chip in very quickly on two of those. The district judges I've spoken to have been somewhat shocked and disappointed at how free litigants in person feel to express themselves in the robustest terms about the justice that they're receiving when it's a telephone hearing rather than face-to-face. And they said they were finding the whole experience pretty tiring and pretty unpleasant. But more broadly, I think virtually everything Tara has just said goes equally for remote mediation. We'll come on to remote mediation in a few minutes. It can work very well, but it does require just that extra bit of thought and preparation, which if you put in, it is absolutely worth it. Sorry, back to you, Tara.
Thank you. And then the final point I was going to make is always arrange a time later in the day to come back before the judge by telephone. That's helpful for a number of reasons. First of all, it really directs the parties' minds in respect of offers and gives them a time to work towards, because otherwise it really, these hearings really could go on forever. Secondly, it's important, just in case you do want to carry on negotiating into the later hours, to be able to have a fallback of further directions that you wish to have made without having to see the judge on another day. And thirdly, just a matter of courtesy, it is important to tell the judge where you've got to. I heard a horrifying story the other day of a private FDR judge expecting to hear back from the parties who had just completely forgotten to tell them that they'd given up and had all gone home. And he was sitting diligently in his room, waiting to hear back from the parties. Of course, that's not the way to do it. What are the advantages if the court can't list the matter for a ENE or FDR in the court process? What might be the advantages of a private ENE and FDR? We appreciate that there is, of course, the additional cost of having an ENE or FDR privately. But that cost, when you look at the advantages, we say shrinks into oblivion, because what you can do when you have a private ENE is you can organise a hearing at incredibly short notice. I've heard of ENEs being organised within 2 weeks that have been successful. You can choose your own judge or evaluator, and given that the sorts of claims we're dealing with here are highly specialised, probate and inheritance claims, what I tend to find is that clients are far more willing to listen to the indication of someone they know is a specialist and willing to adopt what they say, not least because it's the confidence in which your evaluator will tell you what the legal merits are of the case. The judge or evaluator is going to have far greater time to prepare the case and also hear it. You won't just be getting your allotted 1 hour, which might be the case in a busy court list. And I found that as well really aids settlement. And particularly in this current climate, another advantage of a private ENE is it can be conducted in the manner in which the parties choose. As Mark touched upon, there may be cases where it's such a straightforward issue between the parties, or such a single issue, that written submissions might be appropriate and it's all dealt with on paper. You can choose to do that. Secondly, if it's remote, you might want to have it all by video, which I found the courts are far less likely to be able to accommodate. And thirdly, and this is the big thing, that whilst the courts may not be willing to conduct in-person remote in-person ENEs or FDRs, a private evaluator can, if there is an appropriate venue which would be able to allow parties to abide by the social distancing guidelines. And so for those cases where you really feel you need to get the parties there, a private ENE and an FDR is the way forward. And of course, whilst I've said that there's a cost of that judge, the cost saving is immeasurable when you think about a multi-party case going to a full-blown trial. What are the advantages of ENE and FDR over mediation? The first thing to say here, as I said at the outset, is never think of an ENE or FDR as instead of mediation. I would always think of mediation in the first place to ensure that backs are covered in respect of costs. But there are several advantages of an ENE and FDR, and I just want to touch on those. The first is that ENE and FDR is particularly helpful where there is a really big divide or impasse on a particular issue, or any sort of great divergence of views on the law, or if one party has a completely unrealistic view about their case. For instance, that adult child claim in which the adult child can't seem to muster any sort of needs basis and is an able-bodied, independent child. You know his case is pretty hopeless when weighed against a needy spouse, but you really need someone independent to make that clear. That's a perfect case for an ENE or FDR. And as I've said before, clients, parties are really likely to give the views of a judge greater weight, particularly when they're specialised, but also perhaps greater weight than a mediator who isn't really there to give views at all, but more steers the party implicitly towards a settled outcome. The hearing itself can often be faster than a mediation. Well, Mark and I are both mediators, and we've all been there at the mediations that finish in the wee hours of the morning. Yes, ENEs and FDRs tend to be faster. That's perhaps not the strongest advantage of them. I just put here the court's endorsements of ENEs because we think it's helpful if you're trying to persuade the other party to have an ENE, always to be able to rely on some court endorsement. And we've seen in Seals and Seals and Williams, that the court has particularly stressed the advantage of an ENE process in cases which need an authoritative view of the legal issues at the heart of the case. So that's a nice little quote that you might wish to use. There are some, sorry, Mark, yes?
I'm just going to chip in on Williams and Seals. It's important to put that case in context because the court had previously given a ringing endorsement to mediation between those parties, and it seems they had an unsuccessful mediation where they couldn't even really agree the ambit of the dispute that was being mediated. And it's in that context that the judge says this is a case that really could work very well for ENE.
Yes, thank you. There are some disadvantages of ENE and FDR, and these are really reminders for you. The evaluator or judge cannot resolve questions of fact. So if you've got a difficult capacity claim where actually it's solely about the deceased's ability to understand the claims on the estate, etc., it might not be appropriate to have an ENE or FDR in that circumstance. There is always the risk with an ENE and an FDR if a judge isn't dealing with it as well as they might, that it might serve to further entrench one or both parties, and that's always a risk which of course you don't find in mediations. There is, of course, always the risk of a rogue indication or evaluation. I've got to say that risk is probably higher, dare I say it, at court than if you were going to instruct a private FDR judge who's a specialist in the subject. And there's a tactical consideration. If you have an ENE or FDR in a small court centre, then you may be excluding a good judge because whoever's the judge at the ENE or FDR cannot be the judge at trial. So that's a tactical consideration. Mark, I think it's over to you.
Yeah, thank you. So going on to mediation then, we know the advantages. We're all of us, I think, familiar with and comfortable at mediation. It's confidential, it's non-binding, you can pursue it at any stage, although broadly speaking, the earlier the better. The costs are very modest compared with the costs of litigation. And I think some of us may in the past have been rather conservative in our attitudes towards remote mediation, but we've seen in the last couple of months a really good example of how the flexibility of the mediation process is one of its great strengths. It can be conducted in person or remotely, or some combination, depending on the circumstances of the parties and the technology available. And I can recall over the last few years, before there was any question of social distancing, for all different reasons in different cases, having partially remote mediations. On one occasion, a party was in Scotland. She was unable to travel to the mediation, so the solicitor flew up and were on a video link from Scotland. Counsel was present in the room at the mediation. On another occasion, solicitor and counsel were in one room and they had their client in the United States on a video link. So it's long been quite possible to get over geographical and physical boundaries by use of technology. And now we've seen that when you give it a go with a bit of pre-planning and careful consideration, it is possible to run a full mediation very satisfactorily remotely. And of course, it has some of the advantages that Tara has discussed. I know clients I've spoken to in the last couple of months have actually really appreciated not having to travel to a mediation. It's a level of anxiety that is removed for them from the process. We'll recall probably that in the early days of the popularity of mediation, It was drummed into every mediator in part of the training. You must have that joint session at the beginning of the day. And over time, I think most of us saw some joint sessions going badly wrong enough to wonder if it really was a prerequisite. And now it's something which in many, many cases it is dispensed with. And very often one of the principal reasons it's dispensed with is because the parties are really anxious and unhappy about the idea of sitting around the same table, eyeball to start the day. And introducing another level of remoteness reduces that anxiety as well. Of course, it's not a panacea. Of course, there are disadvantages to remote mediation. And I expect and hope that a year from now, while we'll be conducting many more remote mediations, we will still, in appropriate cases, be having those face-to-face mediations with everyone present in the same building.
Mark, I think that's really helpful because a number of, certainly my instructing solicitors have come to me and said, well, you know, how can we make mediation work remotely? And that's something I have said, that actually there have always been aspects of mediation that have been capable of working remotely and have had to work with international disputes remotely before. Yeah. With what I agree with you, that the decline of joint sessions, in fact, it's very capable of working well for mediations because it would just be a matter of the mediator having a video conference with each party and the solicitors, and it's perfectly simple and easy to get everyone either on, we in Chambers use life size, either on that sort of medium or even on the phone, and it can be a compelling and effective way to deal with it.
Yeah, and you now have very sophisticated video conferencing platforms that allow for virtual breakout rooms and all the rest of it. But in essence, a mediation is just a series of meetings. And each one of those meetings can be conducted by way of video conference or, if that's not possible, by telephone. Yeah. So when we go back just to the sort of genesis of modern mediation practice, which is Halsbury and Milton Keynes General NHS Trust back in 2004, what we see there is those features that were being set out, I think in anticipation of being genuine barriers to mediation. As time has progressed over the last 15 years or so, we see each of those has been narrowed and narrowed in its ambit until now there is virtually no case that can reasonably be deemed as unsuitable for mediation per se. Nature of the dispute, we're told time and time again. There's a couple of cases at the bottom of the screen there, Williams and Seals, Wright and Waters. Wright and Waters is particularly notable because it's a judge who has dismissed every element of a claimant's claim in fairly robust terms, nonetheless saying to the parties, this is a case that was ideally suited for mediation. And if we go and look at the Jackson ADR handbook and see what that has to say about so-called very weak cases, it says two things. It says, if you think your opponent's got a very weak case, a mediation is an excellent opportunity to persuade them and bring them round to appreciate that. The other thing it says is you might be wrong. Merits. Just touched on and covered merits there with Wright and Waters. Failure of other settlement attempts. Again, we see time and again parties saying in defence of a failure to mitigate, well, Judge, we just didn't get on. We couldn't have a constructive dialogue. And those of us who have mediated over a period of time know that it is surprisingly often the case that where that dialogue has completely broken down, the mediation proceeds relatively quickly, because once you remove that barrier, once the mediator is able to form a rapport with the parties and be seen as an honest broker between them, not an agent of the other side who have been demonized in the minds of the party, all that is required to get that dialogue up and running is the removal of that barrier. Costs of mediation disproportionate. It will hardly ever be the case that the cost of a mediation is disproportionate. We'll see in a few moments a case which deals with that particular issue. But if you do have a case where resources are modest, where the sums in dispute are small, I would suggest giving serious consideration to ENE, perhaps on paper. Delay, well, certainly at the moment, it's inconceivable you'll have a case where mediation is going to cause a delay in the court process. And prospects of ADR succeeding, it's pure crystal ball gazing, but to make a call on that at an early stage is very brave indeed. Even in Laporte and Christian, where the Commissioner of Police was quite reasonably saying, surely we can't be expected to mediate with everyone who accuses us of wrongful arrest, because as soon as word gets out, we're giving them a few quid to go away, we'll be broke. The judge said, well, who knows? It may not have ever been a prerequisite of a settlement in this case that there was a payment of money, and you know until you try. Arbitration is still very much in its infancy in this area. The area where I think we might see some growth over the next few years is in Talata cases and in Inheritance Act, 75 Act cases, because the family mediation scheme specifically considers itself designed to deal with those sorts of disputes. The great advantage of arbitration is obviously that it's binding. It's a consistent concern that is expressed by parties about mediation. Well, it's an additional cost. What if it's money wasted? I think most of us with a decent amount of experience in mediation would say it's almost never money wasted, because you often resolve the issues and focus the parties on a much narrower dispute than you go in with. And also, I think 80+% of cases get resolved at or very shortly after mediation. So it's a relatively small risk. Arbitration is voluntary, although once you've entered into it, you're stuck with your outcome, but it has all the advantages of being able to design your process, choice of arbitrator, choice of venue, timetabling, deciding the extent of disclosure, all those issues. It is a complete alternative to trial. And what I suspect we may see in the years ahead, particularly if the courts are dealing with a significant backlog post-COVID, the family division are already encouraging people to go to private FDRs. I can see a real impetus towards arbitration as an alternative to trial. The sanctions, we all well understand, because sanctions are draconian if a party fails to take part in ADR. We know that unreasonably refusing or ignoring offers to mediate or enter into some other form of ADR are expressly included in the non-compliant behaviour under para 14 of the Practice Direction on Pre-Action Conduct. I'm just going to gloss over these pretty briefly because I expect you're all well familiar with them, but just remind ourselves, these are really draconian penalties. As I think it was Mr. Justice Newey said in Laporte and Christian, depriving a successful party of their costs is a massive penalty and should not lightly be imposed, but then went on to say there will be cases where an unreasonable refusal to mediate is unreasonable and deserves it, and even in that case knocked off 30% of the successful claimant's cost. Halsey, we've touched on really the sort of the genesis of the whole area. Important to remember how Halsey came about. The Court of Appeal had been running a mediation scheme in the years running up to that, and they'd seen a huge success rate. I remember myself being sent to a mediation back about that time, and I went to see Peter Burt's, retired judge from Kingston, who was leading me in the case, Peter Burt's QC as he was at the time, and I shamefacedly admitted to him that I'd never been to a mediation. Peter said to me, "Nor have I," and I realised just how relatively rare it was. But our case settled at mediation, and the Court of Appeal started thinking, I think, well, if all these appeal cases that haven't even been resolved by a trial in the High Court, if they are getting resolved at mediation, maybe we should push this process much further down the pyramid. PG2SA and OMS, a bit of a landmark case where the court made it absolutely clear that ignoring offers to mediate is as bad, if not worse, than refusing them. You can't just put your head in the sand. You've got to explain why the means of ADR that have been offered is unsuitable. And in practice, what you're normally doing at that stage is saying to the other side, look, we accept this case needs to be resolved. We accept there needs to be a mediation, but please provide us with the following information. It's the perfect case for the defendant who's fed up with getting a robust letter of claim saying, well, that's all very well, but can we have 24 months bank statements, credit card statements, pay slips, all the rest of it, and being stonewalled. That's the opportunity to say, look, we think this would be a wonderful case to mediate, but we can't mediate without this information. It passes the ball back over the net. And Garrett Critchley, and that's sorry, Tara, please.
No, I was just going to say, it's worth highlighting here. The Court of Appeal stressed how you should behave in response to an invitation to mediate. And it's worth me just quickly saying the 4 points that they make. They say, do not ignore the request. Respond promptly in writing, giving clear and full reasons why ADR is not appropriate at the stage, and base it on the Halsbury guidelines if possible. 3, raise any shortage of information evidence with proposals as to how that shortage might be overcome. And 4thly, lastly, do not close off ADR for any kind and for all time. Yeah. So that's how you've got to respond to an invitation.
Yeah, absolutely. And adding into that, perhaps, if you've got a case where you have a good reason for preferring some form of ADR over mediation, that is the time to set out why you have that preference, why mediation you say is unsuitable. But it will much more often be, as the Court of Appeal says, explaining why mediation can't take place at that point and what gaps you need filling before you can proceed. Garrett Critchley's very interesting case, because I think when the Court of Appeal in Halsbury were talking about proportionality, they were talking about the proportionality of the cost of a mediation to the sums in issue. But in fact, in Garrett Critchley, the court says, no, that's the wrong question. What you should be considering is the costs of a mediation as a proportion of the costs of a trial. And it will be vanishingly rare where a trial is going to be cheaper than a mediation. So it really does cut that objection out pretty much for good. Tara, I think we're over to you now for a few more cases.
Thank you. There's also the case of Northrop Grumman Mission Systems Europe Limited and BAE Systems. Mark and I were saying these cost sanctions cases always have very long and complicated names. And this is a case in which a refusal to mediate was just one of the issues that related to conduct in the case. And I think it was a defendant's refusal to mediate was only saved in costs in that case because of a well-timed offer that they'd made. But that's just a warning that really it is a conduct issue which will invariably relate in costs and requires some pretty good conduct the other way to mitigate that. Thacker and Patel is an important case because it says it's not just cases in which a party has refused to mediate or failed to engage in an invitation to mediate. It's also if a party has dragged their feet. And this was a case in which the defendant had accepted an offer to mediate, but just dragged their feet in respect of arranging the mediation, so much so that 9 months later, nothing had been organised. And the court, in making an adverse costs order against the defendant, said that the message which the court sends out in this case is that in a case where bilateral negotiations fail, but mediation is obviously appropriate, it behoves both parties to get on with it. If one party frustrates the process by delaying and dragging its feet for no good reason, that will merit a cost sanction. So a very strict application of the cost sanction rules. We've just included a number of recent cases here for you to have a look at. The case of Simon Kelly and Raymond Kelly is a case in which unusually the court found that it was reasonable for the party, I can't remember, if I'm honest, whether it was a claimant or defendant, to refuse mediation. But in that case, it was a case son against his father. His father had invited him to mediation twice before, and each time he then failed to honour the mediation agreement and had failed to put forward any offers. So the third invitation to mediation, the son said, no, look, you're not honouring the agreement to mediate. This is a waste of time. And the court in that instance said, yes, it was reasonable to refuse mediation. By contrast, DSN and Blackpool Football Club Limited was a case in which one of the parties refused to mediate, merely stating what a good case they had. Of course, that fell on deaf ears as an argument as to reasonableness, and the court made an adverse cost sanction against him. Burgess, Penny and others is a case, it was a want of knowledge and approval claim. And it was in the news because it involved three siblings, a son who was a very wealthy British, I don't know if he was British Airways actually, but an airline pilot, and two sisters. The two sisters have brought the claim to challenge the validity of the mother's will, which had left her estate equally to the three children, saying that their mother would never have wanted to do this because her son was so rich, and of course he shouldn't have got such a big slice of the pie. But anyway, the son invited the sisters to mediate on several occasions, and they refused because they said they would not get an apology from him, and they wanted an apology. Ironically, really, given that at court they wouldn't get an apology either, but that was the basis of their refusal. And Mrs. Catherine Newman QC, who was sitting as a High Court judge, said this: mediation is not just about one side getting what they want. That is a misconception of the purpose of mediation. Mediation should be about attempting to reach a solution which both parties can live with as a better alternative to litigation. So just quite a helpful recent consideration of how important mediation is, and really how it's a very rare case in which it's reasonable to refuse. Just some final thoughts, Mark.
Yeah, and just sort of echoing what Mrs. Newman said in that case, really, that the purpose of mediation is finding that alternative that everyone can live with. I remember when I was a very junior mediator making the mistake of saying in an opening session that we were looking for a solution that everyone was happy with. And I was slapped down by a very wise and experienced solicitor who pointed out to me that if there was a solution that everyone was happy with, they wouldn't have needed him, let alone me. So I think that really is a good lesson, well learned for me in the early days. So that the final thoughts today, I think, just before we take any questions. Firstly, all forms of ADR are possible during COVID-19. We are blessed with technology. My brother, who works in IT, was laughing at my expense the other day, and I was telling him about all the amazing new technology I'd been discovering during lockdown, and he pointed out to me that most of it had been available for about 20 years or more. But certainly the quality and the availability of it is very high. There will be cases, particularly if you've already embarked on litigation, perhaps mediation has failed, or perhaps the value of the claim is very low, that it'd be a good idea to have a look at some of the lesser used forms of ADR. Is it a case where private ENE, a private FDR, or an arbitration might be a way forward? It's early days, but it seems, certainly anecdotally, what I'm hearing and seeing is that most parties and most mediators are pleasantly surprised and broadly positive about remote or partially remote mediation. And as I said earlier, I think it's something which may not replace fully what we might call a conventional or traditional mediation, but certainly something which will likely grow in popularity in the years ahead, as I suspect will private ADR, private FDR, ENE, and in those, perhaps more in those limited areas, I think arbitration may start to make inroads as well. Tara, anything from you in closing?
In early June, Pump Court are holding another virtual seminar, which is on the issue of capacity, and we're honoured to have Professor Howard, who is one of the leading experts in this case, talking us through some of the issues from the medical side, and it's set to be a very interesting seminar or webinar.
Yeah, very much looking forward to that, and be delighted if you could join us. The other absolutely shameless thing I'm going to do is remind you all that the World Cup of Chambers is keeping Twitter ablaze with excitement at the moment, and your votes for Pump Court Chambers in the semi-final would be gratefully received.
Thank you.